Once there was an encampment on public space, for us it was different than on private land, like it is for McGill University. And from there, the Borough of Ville-Marie looked into the bylaws of occupying a public space permanently. And this is where we started to work with we made a request with the SPVM, but also had conversation with the lawyers of the City of Montreal.
So that was City of Montreal Mayor Valérie Plante during Friday's news conference following the dismantling of the encampment at Square Victoria. She was asked about the difference between McGill and Square Victoria and made a whole reference to private versus public property and the use of the courts by McGill, et cetera, et cetera. But on July 2nd, 2024, the Honorable Justice Conan of the Superior Court of Ontario granted an interim interlocutory injunction to the University of Toronto requiring that all structures, tents, encampments, and items of personal property on the front campus and King's College Circle of the university be removed in order to permit the university to have, quote, full enjoyment of its lands, premises, and facilities. And according to reports, the pro-Palestinian protesters subject to the injunction had occupied the area since May 2nd. They've peacefully dismantled. They're gone now. But in Quebec, there are two decisions from Quebec Superior Court judges, two different judges, that did not allow a similar injunction for the similar reasons and similar facts. So to help us try to understand how we can get to two different conclusions for seemingly the same types of situations, I'm now joined by Ari Goldkind, criminal defense lawyer and a legal analyst. He joins me from Toronto. Ari, always a pleasure.
Good to be with you.
So what is your opinion? Because a lot of people, that aren't lawyers, don't follow the law. You say, well, Toronto seems to be the same situation as McGill. So how can we get to two completely different conclusions before the courts?
So it's a good question. I have not. So I will not be able to be helpful on the McGill or Quebec part. I have not read those decisions. I've just read the Toronto one. Mm-hmm. I mean, look, insanity prevails everywhere. the pro-Hamas protesters are winning everywhere. Even though they lost in Toronto, they still won. We can explain why. Mm-hmm. I refuse to call it pro-Palestine. It's much darker and more insidious for this. Most of these people couldn't find it on a map or tell you a single thing about its history. This is pure Jew hate top to bottom. You don't have to agree with me. That's my view. Mm-hmm. And it's one of the reasons why the Toronto decision for the pro-Hamasers was so good. And it is a decision that I think will come back to bite Canadian society. I think it will come back to bite us in the posterior unless you're one of these people that thinks from the river to the sea and intifada now and all these other slogans are just symbols of love and tolerance of the Jewish people and the Jewish state by these so-called Canadians. The reason there could be a difference is because, as I've said to you, Elias, without reading the Superior Court decisions, there is this idea that judges descend from mountaintops and that they never get things wrong. Well, there's human beings behind these decisions, and that's why there's courts of appeal. And that's why there's Supreme Court. So in a very rudimentary, basic way, remember, you can have trials that you and I have talked over the years where a jury has spoken or a judge has come back and wrote a scathing conviction. I say to you on air, it's wrong. It's going to be overturned. The Court of Appeal overturns it and says the judge got it totally wrong. Then the other side takes it to the Supreme Court, and the Supreme Court says, no, the Court of Appeal got it completely wrong and the trial judge got it right. So people need to, let me use a term that I like, curb your enthusiasm about the fact that this is anything other than a human process. Now, the Toronto decision, Elias, can be explained, very simply, even though it's an extraordinarily long 98-page decision. It's a very simple one. So I'm in your hands now.
Well, by the way, you're speaking with David Heurtel. Elias is on paternity leave.
Oh, sorry.
No problem. No problem.
My bad.
I know you're used to speaking with Elias.
I am, yeah.
So no problem. Just so you know who you're speaking with.
Yeah.
But the idea, again, I don't have a lot of time, but I guess from our vantage point here in Montreal, like, okay, that's interesting. There's the whole the private property angle, the freedom of expression angle, and it was interesting to see that a judge interpreting these principles, and I don't think there's a lot of major differences in terms of, civil law being, a French origin and common law on the other side of the river. But the idea here is you disagree with the decision, but from our perspective, we said, wow, okay, there is a way to interpret freedom of expression, freedom to protest, and private property rights versus public property rights in a way that discourages protesters from camping for months on end.
Let me be clear. I'm happy that the injunction went out to clear the encampment. That was the right decision. So let me be very clear.
Okay.
Look, my last name's Goldkind. Your listeners, I don't think, have too much confusion over where I might sit and stand, although I think there are some that are traitors to what I just said. But in any event, the decision in and of itself that says, look, the injunction is granted, there would be irreparable harm if the encampment is allowed to continue, that's fine, okay? And the judge made it very clear, look, these so-called protesters, I think they're more nefarious than that, they're claiming they have the right to run the front campus, to gate it, chain it, lock it, run it as if it's their property. The judge basically said, hold on a second. If it's the University of Toronto's property, why don't they have the right to control what happens with their property? There's 98 pages distilled down to about 2 sentences. The problem that I have with the case is it refuses to call anything that these so-called protesters say is anti-Semitic. It refuses to say that anything that happened there is violent or associated with slogans of Jew hate. Why? Because it takes the easy way out by saying, look, the people involved in this injunction, we didn't catch them saying anything terrible. And it was one of those things where if you watch any media or coverage of what went on down there, I can assure you it wasn't a kumbaya of Jewish acceptance or anything else. It was a bastion of anti-Semitism and purported or threatened violence. The judge, I think, took a very problematic way out, and this will be used, I'll put this very quickly because we're low on time, this will be used by others to say, you can say anything you want about Jews or Israel, and you can go to a superior court in Ontario, and that judge will fudge and do cartwheels and gymnastics and handstands to say, no, it's not anti-Semitic, it's benign, fair language. I mean, that's the problem in the decision, not the ultimate thing that says take the thing down, but you can still protest, just not between 11 p.m. and 7 a.m., because people need to sleep. I'm being serious about the sleep part. That's in the case.
Well, and again, I'm out of time here, but I'll tell you, that's the idea, and I hope we can continue in the following weeks this conversation, because I find it very interesting, because the 2 decisions in Quebec Superior Court just, said, well, this is freedom of expression, and there's this gray area about private property and public space in the university and that. So it'd be very interesting to have your insights on the Quebec decisions. I hope I can convince you to take a look at them, and then we can continue this conversation down the road.
I will read them happily, and I will give you my bottom line without reading them.
I'd love that.
Canada, as we know it, is in big trouble. That's the bottom line.
There you go. So hopefully we can continue this conversation. Ari, appreciate your insights.
Thank you, David.
Ari Goldkind, criminal defense lawyer and legal analyst.